And we start the streaming in 3, 2, 1. You are in the streaming now.
Okay, hello and welcome everyone. This is Sean Flynn. I'm the director of the program on information justice and intellectual property, and I'll be moderating this session, which I think is it's our second PIGIP session sponsored by the Global Expert Network on Copyright User Rights. I think there's actually been quite a few other panels by members of our network as well. So let me just begin with thanks to Charisma, to Carolina and Viviana, and to all the different sponsors of our event. It's been a fabulous global Congress so far, and I'm just very happy we could have it and could continue this community, even though we're still in the situation of not being able to be here in person yet. As I mentioned, this is a session of the Global Expert Network. I think it's appropriate to point out that this is the 10th year anniversary of the Global Congress on IP and Public Interest. The first one was held 10 years ago in August 2011. And that first Congress culminated in the adoption of a declaration on intellectual property and the public interest. And there's a section of that declaration that really has defined the work of this group. And it's a section called Strengthening Limitations and Exceptions. And that part of the declaration called for work on many of the issues that we're doing today. Those included to promote discussion of employing more open-ended limitations and exceptions in national copyright laws, in promoting limitations and exceptions that enable libraries, museums, archives, and other institutions of memory to fulfill their public interest missions, to enable teaching and learning at all levels, to assure that freedom of researchers to engage in large-scale text and data mining or other non-consumptive research, and to advocate for appropriate limits on the use of unfair contracts or technological protection measures that override limitations and exceptions. So I think those, in looking over those in preparation for the last couple of days, I think, many of those still are very, very much prescient in defining a lot of the interests we're focusing on today. There's some that were included in that declaration we've actually achieved. For instance, it endorsed coming up with an international treaty on disability issues several years before the Marrakesh Treaty was actually passed and put into place. So today we hear from members of our network who are mapping the variances between copyright limitations and exceptions in different countries, including on the degree to which education and research materials can be accessed and used in digital education and research projects, which, given COVID, has become one of the primary priorities around the world. And a lot of the research that we're showing today will show that many countries, if not most countries, have inadequate copyright limitations and exceptions to promote online education, to promote text and data mining research, and some of these other issues that were flagged even in that declaration 10 years ago. So I'm going to bring us directly to our panelists. We'll be having, in this order, Teresa Nobre from Communia, talking about education exceptions in comparative copyright. Patricia Diaz next, talking about her work mapping limitations and exceptions in Latin America. Then Caterina and Guilia talking about their work on mapping exceptions in Europe, especially around text and data mining. Lucy Gibault and her work specifically on text and data mining exceptions in a basket of countries. And we'll finish off with Andres Izquierdo, who's from PIGIP with me, who will show a couple of our overall global maps, including mapping education and research exceptions. Given our time, each of our presentations, I'd ask you to be short and keep it to no more than 10 minutes. And I'll give you a little text alert when you're at 9 minutes or so, and that should leave only a few minutes for discussion at the end, because this is a 1 hour session. But if we get to the end and we need more time for discussion, I'll share a Zoom link in which we can bring the audience into an informal room and make sure we have time for audience questions. So feel free to use all our time today in presentations, and then if necessary, we'll move to another room for the discussion. So with that, I'll turn it to Teresa Nobre from Comunia to lead us off. Teresa, to you.
Thank you, Sean. I think, so at Comunia, we have been doing this comparison analysis of exceptions and limitations for several years now. And myself, I've conducted several analyses based not only on mapping the exceptions in terms of rights and the scope of uses that are permitted and the limitations that each of those exceptions have, but also we have used another technique, and maybe that's a bit more directed towards our policy work, which is creating hypothetical scenarios of daily activities where we would analyze, according to the laws, what would seem to be the interpretation of the law in terms of allowing or not allowing that use. And this was very useful, and we have done that work for the discussions in Europe around the new copyright exception for educational purposes, and we have just recently also done that work in countries around the globe with the support also of experts in those regions to support a broader discussion and specifically thinking about remote education and the things that the teachers should be allowed to do under exceptions for purpose of remote education. But today I was not actually planning to focus on that specific scenarios comparison, but instead of showing you our new copyright exceptions.eu, the website that Comunia has been running for several years, and that was revamped just recently with a new version that contains a very detailed analysis of all of the exceptions that exist in the EU copyright law and how they are implemented in different member states. And I think it's an interesting a tool, and especially considering that Patricia is also doing something similar and others are doing something similar, I think it could be interesting to see how this mapping exercise relate to each other. So I'll share my screen, and for a moment you will see yourselves. I'm sorry. And you can see the map that that Comunia has been working on together with different I'm sorry for this, together with different researchers. So this map, as you can see on the left-hand side, this contains a list of all of the exceptions that exist in the EU copyright law. So as you may know, the EU legislature sets a ceiling. So there is a list, an exhaustive list of exceptions that member states can implement in Europe at the national level. And some have implemented those exceptions. So most of them are optional, except for the first ones that you see there, saying DSM, meaning Digital Single Market Directive, which is like the new copyright directive that contains a lot of mandatory exceptions, namely for uses in digital and cross-border teaching, but also for text and data mining. So beyond that, we only have optional exceptions, and therefore they vary a lot in terms of their implementation. So what we have done, and I'm just going to show you, for instance, this one, which is mostly filled in for all the countries. What we have done is analyzing per exception, if the exception is implemented or not, and if it being implemented is implemented in a restrictive way, in a broad way, or in a very restrictive way, in accordance with this blueprint, which is the prototype that is contained for each of the exceptions in the EU law, in the EU directives. So given the space that member states have, and given that they can use that policy space to the full or not, we have categorized and see what they have done. And then I think the most interesting thing, because we had done this in the past in our previous version of this website, so the most interesting thing of this new version is that we really go into the detail of the exception. So let's see one, for instance, here that has implemented. So France has implemented the exception for parody, pastiche, and caricature in a way that closely resembles the prototypes, so follows the wording and therefore the policy space very closely. And if we want to know more about implementation, we click here and you see the implementation details. And we have followed this structure for every of those exceptions, for the education ones, for the research ones, etc. And what you can see here in terms of details is really the scope of protection in terms of the beneficiaries, the purposes, the types of uses that are allowed, but also the subject matter that can be used under these exceptions, if the exceptions is subject to compensation or not, and if there are the conditions, so technical limitations, physical limitations, quantity limitations, time limitations, etc. And then, okay, depending on the exceptions and depending on the level of the knowledge of the expert that contributed to this analysis, you might also have further remarks, such as case law that helps interpret a certain exception. So, and this is, so we do the analysis from different perspectives. So if you click on France, you can see all the exceptions that are implemented in France and all the ones that are not implemented from that list of options that each member state has. But also if you click on the exception itself, and instead of the country, you can see in which countries the exception is implemented or not, and if it's broadly implemented or narrowly implemented, etc. We also have a link for the text in the law that contains this exception, so that everyone can do its own interpretation of the exception. So I think it's a very interesting tool, and we'll see that Patricia has something similar, and we think it can be really helpful not only to show the fragmentation that exists across Europe in this case, but we could also imagine one such map for the entire world, and for policy purposes, but also for research purposes. It's really interesting to be able to see this level of detail. Of course, we are a small group of experts, and we have done this with other organizations, and we so far have relied on different sources, namely some sources that are being collected by Recreate Europe, but we are doing this analysis on our own, using the experts that want to contribute to the project and that already work with us. But because we know that our expertise is limited, we allow others to contribute to this. So all of the information that you will see displayed here is hosted on GitHub. We have a repository there, and any person could contribute to that source and to update and improve the type of information that we have. So it's truly open, truly collaborative, and allows a conversation between experts. So just to end, I will show you the existing education exception. The fact that we have not yet focus education and research exception, the fact that we have not yet inserted much data regarding this exception is because the EU member states are right now implementing the DSM directive, including a new education exception, and the implementation will create definitely a new framework for education and research. and therefore this would be outdated very soon. So in order not to duplicate our work, we have not yet start adding information on this specific text and data mining, research, and education exceptions. So that's it from my side. Thank you.
Perfect, thank you. And you saved us a minute for discussion, which we will save in the end. But Patricia, let's go over to you next. I think your work goes very well following Teresa's. So Patricia.
Perfect, thanks, Jan. I will show you a sister project, like the project that Teresa has presented now. Well, I am Patricia Diaz from the Uruguayan Data and Society Laboratory called DATISOC. Today I'm going to present a work carried out between DATISOC and the Charisma Foundation. This year in April, I think, we published the report on the status of copyright flexibilities in Latin American countries. This report includes the analysis of the legislation of 10 countries, Argentina, Uruguay, Paraguay, Brazil, Panama, Chile, Peru, Mexico, Colombia, and Ecuador. Well, as you know, in Latin American countries, the right granted to authors and to copyright holders do not have more flexibilities than those specifically listed by law. We usually don't have flexible or open clauses or fair use or something like this. And in addition to this, the flexibilities are usually interpreted restrictively, so that new categories cannot be generated by analogy or by appealing to the general principles of law. Those circumstances make necessary the continuous review of copyright limitations and exceptions, taking into account technological advances and new social practices, and to maintain an adequate balance between access and monopoly. So the objective of the project is, in one hand, to analyze the situation of copyright regulations of each country from the point of view of the balance of rights, and in the other hand, is to provide a useful and simple tool for teacher, research teams, libraries, archives, and also for policymakers. Well, we want these actors to understand the scope of national copyright regulations and detect the presence or absence of flexibilities. Let me show you my screen and show you the website. Here, are you seeing my screen? Yes, well, I think you are seeing. This is the website. It is in Spanish, and now I'm using my browser's translator to display it. That's why you will find some translation errors. From here, you can download the report here in the right. And in addition to the report, we have developed a database and a tool very similar from the tool that Teresa has shown first. Let's go here. Well, this is a tool with interactive maps. To do this, we explored the commonly permitted uses of works in comparative law to construct broad categories of expected exemptions and limitations, and really broad categories. And we classify them based on the main purposes or functions that they fulfill in relation to safeguarding the general interest. In the glossary, here you have a glossary. You will find the extended description of the purposes and categories. Yes, I show you. Well, in the map, purposes are displayed together with a series of categories built on the basis of several commonly accepted uses in comparative law, as I said before. By the way, some previous documents published by PSHIP years ago, such as the enumeration of presumptively lawful purposes and the master list of limitation and exemptions in national laws, were very useful to contribute and very useful contributions to our investigation. The situation of each country, of each copyright flexibility in the 10 countries is compared using a traffic light system, green, yellow, and red. These categories are defined here, and you can find in the report a lot of methodology criteria. I'm not going to expose them now. But in general, the exception exists, is insufficient or is enough to safeguard the public interest. These are the classification of exemptions. Well, let's take a quick look at the categories and the purposes. First one is contribute to criticize public discourse and freedom of speech. For example, here it is not appointment, it is quotation. For example, here we see that the countries in yellow have problems in the quotation rights. If we read the different laws, we find that the audiovisual quotation is not foreseen in yellow countries. We can, if you select a country and click on it, you can, yes, you can see the text of the law and the exemption, and you can also go to the source in WIPO database. Another example, for example, here, parody and related. Here we find it is the situation of parody and related exemptions. We find that Uruguay, Argentina, Mexico, and Paraguay do not have any exceptions that enable uses of works for parody or satire or caricature or memes, for example. In purpose 2, we find that it's promote face-to-face and online education. Here, for example, we find that the only country in Latin America that has clear and specific exceptions for online education is Ecuador. And you can read the exception here. Purpose 3 is promote access and preservation of cultural heritage. Here, for example, we see the situation of public loans or for libraries. And we also see that here, for example, in orphan works, we also see that 8 of 10 countries do not have any provision to solve the situation of orphan works. This is exponentially increased the transactions and cost of the any digitization project in Latin America, for example. Well, next is underserved population is safeguarding, expand access for underserved population. Here we can see how the Latin American countries have implemented the Marrakesh Treaty. And also we analyze the existence of exemptions or compulsory licenses for translation of works to minority languages. Here, for example. The next is safeguard incidental, private, or social uses of works. For example, we can see the situation of private copying for strictly personal uses, and freedom of panorama. Here, we find that Uruguay and Argentina don't have any provisions on freedom of panorama. Next category is ensuring proper performance on public administration. And finally, the last one is enabling and taking advantage of beneficial new technologies and uses not yet foreseen. If we click here on links and frames, we can see that the only country that has a regime related to links and frames is Ecuador. The other countries do not have any provision on this. In Uruguay, at least, we have detected complaints from collective managers for the use of frames or on audiovisual works, for example. Well, finally, I will stop sharing my screen. This mapping, with this mapping, we are able to confirm something that we already knew, is that the normative anachronism of our region. But something important is that we can present evidence and show it in a systematic and in a graphic way. Obviously, there are different levels of legislative backwardness. There are some exemptions. This is the case of Ecuadorian legislation, which we consider that is a good legislation in terms of balance, and it has some very original legal provisions. Well, finally, it is not a finished project. We plan to update the site monitoring copyright reforms and expand and improve the definition of categories, expanding the scope by adding 10 more Latin American countries next year. We will make the website mobile responsive because it is not mobile responsive now. Well, that's it. Thank you.
Thank you, Patricia. That was outstanding and right on the time. Caterina and Guilia, would you like to go first?
Sure. Thank you, Sean. Thank you for having us here with you today. Now, Guilia is sharing the screen for our presentation.
Hope it works.
It does. Wonderful. Thank you, Guilia. So let's briefly start. I am an associate professor of private comparative law at Scuola Superiore Sant'Anna in Pisa. And Guilia is at the moment, and for still a couple of days, a postdoctoral researcher at Sant'Anna, moving to Nova University of Lisboa as assistant professor in a couple of days. I am the coordinator of this project called Recreating Europe. It's a project funded by the European Commission in January 2020. It's a broader project covering several aspects of digital copyright law from the perspective of different stakeholders. The focus of our presentation of today is just on the activities we are conducting in a particular work package, which is the second, focusing on end users and special vulnerable groups, in the context of which we conducted EU and comparative national legal mapping across the EU of copyright flexibilities. I'm going to give you a brief overview of what the mapping is about, and then Guilia will dig into details of the particular focus of today. Next slide. Guilia? Can you go? Okay, thanks. Now I can see the next. So the focus of this work package, as I said, is on end users, is to access to culture and particular vulnerable groups, such as people with visual impairments or academics, because yes, we consider academics among vulnerable groups, and other specific socially or economically disadvantaged individuals. The legal mapping we conducted is on a broader range of tools that can be linked to the notion of copyright flexibility. So even if we are mostly mapping continental legal systems where exceptions and limitations play a key role in driving the copyright balance, we decided instead to have a look at all regulatory tools that contribute to this balance. So in the questionnaire we administered and in the mapping we conducted at the EU level, we also looked at provisions such as those referring to free and paying public domain, specific provisions on licenses, particularly statutory licenses, extended collective licensing and the like, principle of exhaustion and its potential extension to the digital environment, and so forth. What we realized, and that was really one of the first findings we had, is that we don't really have an overarching definition of copyright flexibilities in the EU literature, and probably mostly scholarly literature. And our aim was to not to just do a theoretical exercise in this respect, but to see if we can really trace some recurrent main threads all across copyright flexibilities, and in which way these, in which direction these threads are actually contributing to balancing between copyright and opposite public interest or conflicting fundamental rights. Next slide. So which methodology did we apply? Actually, the legal mapping exercise was not just conducted on public legal sources. That was what Sant'Anna did, but our partner university, partner group in Szeged also conducted a mapping of various type of end user license agreement, from platform giving access to protected content to verify to which extent users' rights and freedoms have been compressed by contracts. So to which extent copyright flexibilities were overridden by contracts and with which effect. The overview of today is just and mostly limited to our analysis of public legal sources. What we mapped was a wide range of statutes and other regulatory sources, and also, most importantly, case law from all member states. This gave us the possibility to verify, on the one hand, the level of reception of Court of Justice of the European Union doctrines and principles, which are pushing towards harmonization, and also to verify which type of harmonization we have bottom-up from national courts in areas that are not covered by EU directives. So to verify to which extent copyright flexibilities are converging or diverging across member states. The mapping of EU sources was performed in-house in Sant'Anna with desk research, while for national legal mapping, we referred to national experts from all member states. 36 people were involved. And from the responses we got, the questionnaires were developed in a semi-structured manner, applying comparative law methods, so broadly intended. All the responses which we collected from September to December 2020 were coded in spreadsheets, and we are now in the phase of updating those questionnaires on the basis of what happened after the CDSM directive, and of course what happened in the past year in terms of case law and the like. Together with this and parallel to this, we are also conducting interviews with policymakers at the national and EU level to check which type of consultative exercise or other type of stakeholders' involvement and practices they carried out in reflecting on copyright flexibilities, verifying the state of copyright flexibilities, and so on. So to read beyond, behind and beyond the lines of actual reforms. We are also preparing comparative reports for each type and categories of users, and these reports are going to guide the consultation of the database, the public database of all the materials we collected, so of national and EU copyright flexibilities, both in statutes and case law, because our aim is not just to make publicly available all the materials in, of course, in home language, so translated just at the level of summary. Our aim is to make this material understandable also for people who are not actually skilled in the art, we can say, so copyright scholars and the like. The public database will come online in the second half of 2022, and it will be flanked by an open access publication of all comparative reports and national questionnaire and best practices and policy recommendations. Now I leave the floor to Giulia for a focus on a particular type of copyright flexibility we analyzed and what the findings were.
Thank you very much. I hope you can hear me well. There seems to be a little bit of a delay in the slides, but I just move. I just have 2 slides, so hopefully it will work for a few more minutes. As Caterina just explained, now for more than almost 2 years, more than 1 year, we've been collecting and systematizing an impressive amount of data, and I'm sure that colleagues and friends in these panels can totally understand our effort as they've been mapping also legislation on this topic. What we aimed with this mapping effort was definitely to have an up-to-date, clear-cut picture of copyright flexibilities in Europe, but also we were, and we still are aware of the fact that simply counting how many provisions explicitly address certain copyright flexibilities wouldn't have told us much about the real scope and shape and size of these legal spaces that are explicitly or specifically dedicated to end users and access to culture. So what you see in the slides basically right now is a sort of a first picture that we drew some months ago from our preliminary finding of the mapping. So before starting the second phase of our research, which deals more closely with the comparative analysis of all the collected legal data and trying to make a sense of the question, is the real life legal scenario to some extent similar or significantly different from the picture we see, from the numbers of provisions that we have across Europe tackling copyright flexibilities and allowing the presence of permitted uses in a access to culture that is flourishing. So the exercise we're doing right now obviously is very vast in its nature because we cover pretty much all copyright flexibilities, meaning what Caterina just highlighted, not only the copyright exceptions that we have listed exhaustively in the European legislation, but also all the types of copyright flexibilities that go also a little bit beyond, towards direction of public domain, towards direction of licensing, and towards the understanding of notions like access to culture and end users' rights. So what we are doing now, and I just wanted to share with you a second slide, is actually drawing our first research findings. So from our comparative studies of the data, and again, this is an ongoing exercise, so this is really a preliminary result kind of overview, we seem to identify 3 main patterns that are emerging as most consistent observations, almost empirical observation from our study of the legislation, case law, and also the interaction we have with our national experts on a comparative relevance. So first of all, I will draw some examples that directly relate to the uses or copyright flexibilities for research purposes, because that also seems to be a common interest in this panel. So the first pattern we identified as a preliminary finding is a sort of double fragmentation of the legislation on copyright flexibilities. So not only on research uses, but that happens to be also a very good example. Teaching and research uses seem to witness a fragmentation that we are all well aware about, having mostly optional provisions and copyright exceptions at EU level, but then different choices from national legislators and policymakers in which and how to implement those provisions. But then even when provisions, for example, Article 5.3a of the InfoSoc Directive that talks and allows national legislators to implement a teaching and research exception, well, also when these exceptions are broadly implemented and we have substantially harmonized rules, we still lack a common legal understanding of, for example, in this case, what doing research is about and what this really implies. So when we look more closely at this article I just mentioned to you, Article 5.3a, you can have an exception to permit free uses for illustration for teaching and scientific research. Well, we see that some countries jointly implement this provision with the quotation exception, for example, France and Italy. And you have other countries that put more emphasis on, well, this provision talks about inclusion of scientific works in other material, for example, in educational materials or policy materials. And that is what we want free. So that's, for example, the wording that seems to suggest Bulgaria. Or we have few member states that seem to take the occasion to carve out broader legal space for end users and access to culture, and simply talk about the free private use of scientific content, for example, Croatia. So in this sense, we are challenged by a double fragmentation of almost everywhere harmonized rules on teaching and research purpose uses. And we have, unfortunately, very little case law that supports our doubts and our needs for clarification in order to understand whether within the European Union we really mean the research use exception in the same way. Very briefly, the second pattern we identified as preliminary finding is actually something that probably is also overlooked, but once mentioned, every one of us seem to know and remember. There are so many key legal concepts that even in the case, once again, of a harmonized or substantially harmonized copyright exceptions are still left unaddressed by a European interpretation. So definitely the Court of Justice of the EU has been playing a key and proactive role in promoting harmonization and giving us more information about how to interpret legislation in a more cohesive and harmonized ways. But this seems to be somehow this seems to have had a limited impact, because we see legislation in national courts still grappling with definitions that are not very clear-cut. For example, the definition of scientific institution or definition of what is private studying and private research, or still the definition of self-archiving practices. What does this mean across Europe? So that's a little bit what we can start sharing with you, because we are really much in the middle of the comparative studies of these key notions. And the third and last point we wanted to highlight, that's actually an observation that we developed working closely together with our colleagues at the University of Szeged, who work on the private ordering and copyright flexibility. So there seems to be a big room for contractual agreement and contractual freedom. And this is not just with regards to contractual overreadability of copyright exceptions and flexibilities, but rather there seems to be an uncertainty on how and to what extent this overreadability really plays out in the real world. And this has obviously a lot to do also with something that was mentioned in the presentations before about extended collecting licensing and institutions and publisher contracts in terms of legal clarity and legal awareness across our stakeholders. So I think on this note, I just conclude, and I invite everyone who's interested in our work to keep an eye on Recreating Europe website, because there is a lot also on the Zenodo page. Our research, part of our research is already available there, and more is upcoming online. So thank you very much.
Thank you, Julia. And Lucy, straight to you. Lucy Jabot from the Dalhousie University. And Lucy's been looking at text and data mining research exceptions. Lucy?
Yes, hello everyone. Thank you for having me on the panel. I'm very happy to be here today. And I would like to talk to you indeed about empirical research between copyright exceptions and the activities of text and data mining. So if you allow me to share my screen, I will try to do so. I'm not sure how to share.
Is it working? It should be a green.
There's a green. I have the choice between desktop 1 and desktop 2 because I have two screens.
The one with the PowerPoint.
Yeah, but it doesn't show me much. Open system preferences. Please forgive me for this.
I'll tell you if you get the wrong one, if you want to just try one.
Now it wants the password. My computer. I have to allow Zoom. Oh, and he wants me to quit and reopen. So this is not what I want to do. Don't want to quit and reopen. So I'm sorry, but I'm not able to share my screen this morning because of technical issue. So I will describe to you what the research was. So this was a common project together with Christian Hanke, who's an economist at the Rotterdam University, and Joao Pep Valbe from University of Barcelona. We were three colleagues of different disciplines, an economist in Christian and a social scientist in Pep, and myself, the legal analysis. And we worked together to indeed do, for the first time for me at least, quantitative analysis, empirical analysis, in looking at really copyright's impact on text and data mining activities and research. So I'm, okay.
I can find the paper maybe and show it if you want.
You want me to try again? Ah, yes. Thank you. Oh, that's.
You're there. That's the right one.
So you can see it?
Yes. Just make
Yeah, because I have a little window.
It's fine. Just make it full screen.
Yes. Okay. Looking for my cursor, so I'm sorry. I'm usually better at this. Ah, okay, good. So now we're in business. So the research. We did a sample of 42 countries with the highest GDP, because our assumption was in countries with a higher GDP, you would have greater research activities and get greater research output. So it turned out that most of the European countries, North America, Australia, New Zealand, and a number of other countries across the world were included in the sample. And what did we do? So this was mainly Christian Hanke's task, where we decided that the best database to go look for articles relating or describing text and data mining as a methodology would be the Web of Science, also because Web of Science is more easily accessible. And so Christian did the research and analyzed the outputs from the 1992 to 2014 time span, using as a keyword search data mining and other synonyms. So he tested different terminology to refer to the methodology of text or data mining. And in the end, it was rather neutral in that terms, and he used it not in the title description of the Web of Science article, but more in topic. And the research output was as follows. in that period of time, there were 23.8 million articles published in Web of Science, and 18,441 were text and data mining related articles in that same period. And that means 966 country observations, which translate into a 0.77% of all articles had TDM as a topic for that period of time. Then our key variable was, when you have this sample of articles, was, is specific permission required to engage in text and data mining activities? So is it allowed or is it not allowed? Is it allowed in relation to the exception on copyright at the time? And this changed over time. So basically the classification of countries is as follows. So remember, the sample was from 1992 to 2014. So this is a project that took a while to come to a final publication, because we refined the methodology and the regressions quite a bit. But the legal analysis was as follows. I ranked basically the countries in the sample. Remember, we had a sample of 42 countries, between countries where TDM would not be allowed, would probably not be allowed, would probably be allowed, and would be allowed. And I'll break down a bit the sample here. I have put the European countries and Latin America, and I think that Patricia's research will clearly demonstrate this, although Patricia's research is for now, for the law now, but you can put yourself back in 2014, would have been the same, I think. But at the time, I did put the European countries in the not allowed, because when you think of what happens when you do text and data mining, you make reproductions, you make vast amounts of reproductions of vast amount of texts. And although some reproductions for private use are allowed in most countries of the European Union, the problem to me in analyzing this type of activity was the massive amount of text copied, and the fact that all those texts were integrally copied. And not only does European Union have a rather restrictive approach to private copying under copyright law, the European Union also has a database right, which protects the makers of databases that show substantial investment, qualitative or quantitative, in the collection, verification, and presentation of the database. So if you put the database right in its context, I would think that most publishers in Europe would benefit from a database right. And the database right does not apply to any type of electronic database. So invoking the database is per se not allowed activity in European Union at the time. So the countries probably not allowed would have a narrow reading of fair dealing, and sometimes a broader exception mechanism, but probably my interpretation of those case law or limitations was that probably the extent of reproduction needed to engage in text and data mining would not be allowed. And this is actually something that changed over time between the 1992 and 2014 period, where I changed the category of certain countries from probably not allowed to probably allowed, because of the reading of fair dealing and fair use in the course of time. So for example, Canada had a rather restrictive reading of fair dealing until 2012, where both copyright reform by the legislator and a series of Supreme Court decisions of Canada really broadened the scope and extent of fair dealing in Canada. So my interpretation was that it switched from probably not allowed to probably allowed. And the last category of countries were fully allowed, but those at the time, in that time frame, we only had 2 countries basically that had a specific exception allowing text and data mining, and that's Japan. And at the very late last period of the sample period, UK also got a exception allowing text and data mining. So I looked at legislation and available case laws many times through secondary literature. So this is actually my interpretation of comparative law. And the regression also took account of the compliance with the rule of law. So the World Bank issues its rule of law index, and part of the regressions that we did in analyzing the impact of the strictness of the copyright regime on the activities, we also took the rule of law in the model. And this is a descriptive statistics regarding the text and data mining share of copyright categories. And you see in the probably allowed, this share increases as such. So I spare you the regression tables that are published in the article that we published together. And you see here the reference is our article was published in the Managerial and Decision Economics 2021. So the publication is recent, even if the sample is a bit older, but the regressions are really very solid, taking all factors into consideration. And the result is, as we refined the methodology over time, the result is that there's a clear correlation between the more flexible copyright exceptions and the activities of text and data mining. So in reverse, having a strict copyright regime does hinder the use of text and data mining methods in research. So we're very happy with the results, and especially while refining the methodology, following the peer reviewers' comments, it actually strengthens the positive correlation of our model. So this is it. Thank you very much.
Great. Thank you, Lucy, for that empirical demonstration that sometimes law works, which is a great thing to find sometimes. Andres, so we have you wrapping up with some of the results of PIGIP's research related to both of these areas. Andres, I can't
Can you
hear.
see the screen now?
There we go. Yeah, we can see the screen.
Okay, perfect. Thank you. Thank you, Lucy. Thank you, Sean. Thank you, Charisma and Global Congress. Good morning, afternoon, and evening to everyone. I'm Andres Izquierdo, Senior Research Analyst in International Intellectual Property at the Program on Information Justice and Intellectual Property at American University, Washington College of Law. I'm here to present PIGIP's mapping projects on the right to research and education in global copyright laws. PIGIP has reviewed the copyright laws of more or less 180 countries on the degree to which they protect user rights related to research and education. I'm going to focus here on our mapping on research rights. If we have time at the end, well, we will also be happy to show our mapping on education rights as well. So, okay, this map of the world, let me move it corrected. There, that should look better. This map of the world based on whether the countries in it possess adequate rights to research on the phase to permit a text and data mining research project. TDM research projects create a corpus of works and mine that corpus with algorithms to extract information from and about the corpus of works. We are examining the scope of copyright exceptions, which is different from asking whether something is allowed or not. We do not determine whether the scope of copyright in a country might not cover the kinds of machine reading involved in TDM projects. If you need to rely on an exception, a fact we do not determine, then this map helps you determine the scope of the most applicable exception. Here again, we do not determine how courts would address the questions, which may be influenced by local interpretative norms we not know nothing about. This is a map only on how open the plain language of the research exception in the law appears to be. So we assume you need to know two kinds of rights under copyright. There are two very important rights that we have to have in mind. One is reproduction rights, and the second one is communication rights. Researchers need to reproduce whole works into databases that can be searched and analyzed by computers. TDM research also needs to communicate works and corpuses for collaboration and validation. Some of this research may also need to happen across borders. Essentially, the green countries that you see in the screen are those that have adequate research rights to allow TDM research on their face, and the red countries do not. All the rest can be considered yellow. Only, I mean, they must be used with caution. There are a host of restrictions in the yellow countries. Restrictions, for example, restrictions on types of works that can be used, on types of users, for example, only public libraries that can use, and on the purposes of the use, for example, restrictions to a private and often non-commercial purpose. This map does not mean that you can actually perform TDM or that you cannot perform TDM in these countries. As I said before, we do not consider actual court cases in countries that might determine that a particular project is or is not within the exception. And we make an assumption about that interpretation, that the law will be interpreted or used liberally along the lines of the Canadian Supreme Court, that not all countries will in fact follow. So don't rely on this for your legal counsel. So now we can see the map. This map just moved a little bit. Wait, the map moved a bit. I think the map needs to be reduced a little bit so it fits on the screen. Sorry about that. There should be now working. Yes. So this version of the map breaks out all the caution signs into their constituent parts. Green, for example, as I was speaking before, we rated all countries with a fully open research exception in green. Fully open exceptions are those that apply to reproduction and communication rights and apply to all uses of all kinds of works by all kinds of users. Note that we ask our question differently than Lucy's work, which accords the highest value for specific authorizations of text and data mining activities. We are asking a different question. Blue, on the other hand, we use blue to identify countries by which their domestic law only covers reproduction, but not communication rights. Light blue, that you can find it in many countries, are countries that only protect research through individual private reproduction rights, restricting uses by institutional and commercial users. Purple, that is not that often to be found, but is there, restricts research use rights to certain institutions, often non-profit libraries or research institutions or archives too. This is another type of restriction on the types of users. And yellow, that we can find it a big part on Asia, also some countries in Africa, a couple in Latin America. We use this classification for laws that only allow research uses of certain kinds of works. France on our map is also yellow, and it's because it limits research to uses of scientific works. Russia and many others allow uses of articles, but not the whole works, not the whole books. And red, that it's very marked for Latin America, limit research. It limits the research, limits the exception only for excerpts. So all TDM uses require whole works, so it will be practically very complicated. What we do not establish here is whether TDM is or is not allowed in each country. a red country could decide that TDM activity is wholly outside of copyright protection because it is an act of reading, not copying, to have computers collect and crawl through copyrighted materials. So maybe a country could say in Latin America, this is not part of copyright law, so it would not be addressed on that way. There are scholars in our network who endorse that view. We ask only whether an exception in the statute could be allowed to permit TDM, not that it will. So this leaves us, sorry, again, I have this leaves us with our last slide, that is on there. Well, let me conclude with a reference to the policy work of the Access to Knowledge Coalition at WIPO. One area of potential norm setting at WIPO is around cross-border uses of copyrighted materials. One simple solution to part of the problem would be a cross-border use clause modeled on the Marrakesh Treaty. Argentina, some years ago, proposed such a solution in the 33rd SCCR. The civil society proposed treaty instrument on educational and research uses, TERRA, also known as TERRA, includes a short refined provision. The effect of such a rule, and the one of cross borders, the effect of such a rule would, like Marrakesh, open up access to materials and collaboration without any change to domestic law. A researcher, for example, in a red country that only permits uses of excerpts, for example, could still access and contribute to research corpuses housed in other countries. It would make clear that our researchers do not have to move out of our countries because they want to contribute to and collaborate with the most complex and advanced research projects in the world. Thank you for taking the time to listen to this presentation.
Thank you, Andres. So I understand we have 20 minutes left in this session. So organizers, please correct me if I'm wrong, but if that's correct, then we can have a little bit of discussion between us. Let me start with an open question to kind of all the panelists, and that's that the Global Congress traditionally is a forum that brings together researchers on one side, but then also advocates on another. And some of the panelists on this panel are advocates as well as researchers, for instance. But let me ask you, how would you like policy advocates to use your work, to use your mapping? How could they use what you found in their work? How do you think it can be useful to policy advocacy communities? So maybe we'll just go in order. Teresa Nobre, I mean, you all created this as part of a policy advocacy tool. Maybe you could lead us off by describing how are you using this in practice now?
Thank you, Sean. I think that's a good question for all of us. So indeed, when we started, and this was when we did our first comparison, was back in 2014, was before the European Union initiated the proposal to harmonize educational and research uses in the European Union. And it was part of an effort to convince them that this needed to be harmonized. So what we did was going there to events, to meetings with the European Commission, but also with members of the European Parliament, and present these tools that were, you know, from a visual perspective, you understand right away the problems because you see these maps with colors and you see how complex it is. And I think for the European Union, because we are trying to achieve a digital single market, it's easy to understand for policymakers to understand that if you want to achieve this single market, you cannot have this fragmentation because you cannot have a cross-border collaboration within the European Union, cross-border, you know, the European Union had all these joint educational programs. So it was very easy to make the case with these maps. But then we saw that we were also not really reaching everyone because we have to make sure, you know, we have to bear in mind that policymakers that deal with copyright, they are not necessarily experts on copyright. So they are dealing with tons of different issues. So that's when we came up with this idea of going a step further and creating these scenarios where I would ask, so instead of just showing a map with reproductions, communication to the public, yes or no, I would really bring scenarios and analyze them from my own interpretation, sometimes with support from local experts. And then I could say, show a map, but show a map of scenarios and ask, can a teacher, show a short YouTube video in class? Can a teacher send something by email? And I think that was even easier to make the case that the fragmentation was really having a real life impact on the daily activities of these professionals and the education communities, etc. So that's where I think anyone working on policies could use our type of maps to approach their policy officers and say, look, either we are behind or we are better, but we cannot interact with others because of all of this fragmentation. I think it's a very powerful tool. And actually, I should say, Patricia, that I just directed one of our partners in Europe, which was going to approach a development agency to show the Latin American map, because the development agency is looking at the global south, and of course the European map doesn't matter for them, but they showed the development agency your map of Latin America, and they were really surprised, and it was very easy for them to understand the issues. So that's, I think you can build on this. So provided that, you believe that this research is correct, you don't need to do your own research again, but just build new tools, new scenarios, new things on this, or just show this one right away. And I think for us ourselves, I think it would be nice if we could come up with a global map and trying to bring all of our materials together, because that would really be impactful on an international policy level when we go to WIPO and talk with policymakers that might be willing to change things at the international level.
Yeah, I think that's it's another one of the notes that I had written down actually is, how can we combine this analysis? We all ask slightly different questions, so it will require some additional analysis or maybe even changing methodologies to bring them together. But I do wonder if there's the possibility of bringing that together or how we might do it. Let me just go around to each person. You can really answer whatever question you want, but we have at least two good ones right on the table, which is how might your research be used by policy advocates or policymakers? Also, how might we combine our analysis? But let me just ask you the open-ended question of, what you'd like to call attention to. What are some of the most important takeaways that you're reaching, today by interacting with others? But so Patricia, let's go in the order that we came. But what do you think about any of those?
Yes, I'm not very fluent in English. That's why I have a short answer for your question.
Yes.
Our tool, our website with maps is a first approach to the subject. We think that laws must be interpreted in context, and we do not analyze jurisprudence or how it works in the laws work in the practice in each country, and also, we know that Latin American institutions, education and research institutions do not have enough copyright literacy. That's why we think that our tool, the objective of our tool is copyright literacy for who? For institutions, researchers, and for policymakers, mostly for policymakers. But we know that we make another research We are now working on scenarios. For example, in Uruguay, we did a encuesta. Well, I don't know how to say it in English. We are working in scenarios and in how it's working in practice in each country. And now we are developing another research on related directly on text and data mining and what it is happening in practice. So it is an issue or it is not an issue. Our tool is copyright literacy. I think it is copyright literacy at first approximation, but we need to do more research. That's the answer.
Always good to end with, we need more research. Caterina and Julia.
Thank you. So I will try to touch briefly on the 3 points, the 3 questions you raised. The first one, how can policy advisors and policymakers use our work? I think that differently than pure mapping, visual mapping, that are more for immediate scenarios, immediate points, the type of mapping we wanted to propose is directed to evidence-based decision-making. So to provide ready-made evidence that don't need to be searched for once again, but they can be machine searched, they can be commented upon, they can be pinpointed when some statements are made straightforwardly. And there is nothing like that at all out there, particularly not at the level of details we want to provide. That's why we imagine this database that contains first-hand sources. Comparative reports have the very same aim of your mapping. So help people navigate without digging into those sources. And this brings me to your second question. How can we harmonize the mapping we're doing in order to make this instrument useful also before policy fora that are more international? Well, I think that a blend between the two will be the way forward, meaning that we already have overlaps at the European level, probably using the very same methodology with national experts or using existing database that by putting it together with the existing database that WIPO has, could give us the possibility to create a repository that is still not existing. And that would help policymakers at an international level to make their case on the complete lack of harmonization of exceptions or the fragmentation of exceptions, and where does this lead? And I think that, and this, just to be short, leads to the third point, that is, what is the general takeaway? What do I see? That we are showing what are the effects, the worldwide effects of an international standardization of copyright law that paid far too much attention to exclusive rights, which are now mostly standardized internationally and converging, but didn't care much about copyright flexibilities, leaving them up to member states, which now just creates uncertainty and frustrates cross-border uses, which will be the most important element to take into account for access to knowledge and circulation of knowledge cross-border, now that the digital environment makes this possible with reduced transaction cost. So this is the way forward, and this is what a mapping like ours would possibly showcase in the best manner possible. But that's just an exciting starting point for next work ahead.
I think that is an exciting starting point. Thank you. Lucy.
So well said, Caterina. Thank you. So I was not engaged in mapping, at least not in this project. It was more empirical research. And I must say that the empirical research, we've published a first version of this article back in 2015. And I mean, we took a long time and different activities came within it that delayed the final publication and peer review, etc. But the very first publication of this research and the obvious result that copyright does have an impact on research activities, was, I think, a bit the trigger to get the countries in Europe talking. And there was a lot of research that followed and policy work that followed at the European level. And now we have, of course, the directive on digital single market. And well, I don't want to give myself more credit than I deserve, but I do think that all the research that was done, including this paper, that showed clearly what the impact of copyright has on research was a determining factor in the direction that the lobby and the discussions in the context of the digital single market directive took place. So now today in Europe, at least, countries are about to implement a much flexible regime for text and data mining, and that's very good. So empirical research basically does make a difference in policy work, absolutely. So when you can demonstrate with numbers that a policy has an impact, then it's food for thought. So how to merge or to converge our different projects together? I think we need to sit down at the table and to discuss terminology and methodology and harmonize our ways of working, because I did notice a difference between our project or my vision of the flexibilities across the countries and Andreas and Sean's project. So I think we need to discuss together. And in terms of pure policy, what I really want to say is there's a wind that's blowing, at least in Europe and in many, many countries around the world, about open science. Open science is a very big thing in Europe, and it's picking up ground in many, many countries. So there's a disjunct right now between the world of research and government support for research, because all the funding agencies across the world are going more and more the open access way and the open science way, and open science all the way. But you're now seeing the obstacles put by copyright, and so also the communities need to talk to each other. And if we really want to make sure that the objectives of open science are realized in practice, we will need to address copyright issues and database right issues in Europe as well.
Yeah, very true. Andres.
Thank you, Sean. Yeah, I agree, Lucy. It would be very good to get together and discuss a little bit our terminology. Yes, I mean, in general terms, if the question is what do we want policymakers to do, I think I would like local policymakers to use this information in 3 different ways, although there are many other options. But first, it could be policymakers can ask their local copyright office for a legal interpretation on TDM with relation to their copyright norms. Like how to use, where is TDM located in their copyright norms? So as a result, users can know how to understand and act towards TDM projects, because right now there's a big lack of information. A more long-term measure could be to ask their national Congress, their local Congress, to update their copyright laws, maybe to include a general open exception or a specific open exception for TDM activities, such as the ones that have been passed in Japan or recently in Singapore. Also, the best case scenario would be that maybe they will just exclude TDM from all the copyright laws. That would be like also an option. A third option is the one that we focus more at PIB, is on an international level, where policymakers could talk. I mean, if we're talking about local policymakers, we could say that local policymakers could talk with their local copyright office to work jointly with the diplomatic missions in Geneva or the WIPO coordinator to make changes at WIPO or at the World Trade Organization. Those are just like a brainstorm of options.
Fantastic, great. I think that was a really great discussion and a good place to end it. I think we have a minute left if anybody wants to jump in, but otherwise, I think I'll close this session by thanking all our presenters. This is the second time we've gotten together, and I think it's really nice to have these projects speaking to each other. And I really do want to follow up on the idea of making this a global project. So I hope everybody has, through their comments today, joined that process. But I do think it would be really interesting. And Patricia, especially, I really like your mapping project, and I hope we can follow something like that. It's similar to Teresa's as well, but something that shows, I really like the ability to show the law, not just our interpretation of it. So a user can really actually test our judgments. I think that's a really useful tool. So I hope we can collaborate on that. And I would love to find a way to get all this helpful information in a similar location. So expect future invitations to try to work towards those goals. But for now, I will just thank you all and say that it's great to see you again. And I think that will be it. I think actually we've elongated this session, so I don't think we need the second room. So I will bid you adieu. Thanks, everybody.